Hello. The question we are talking about today is how to file a lawsuit in defamation. The full question was how to file a lawsuit in defamation of character, but at least here in Quebec, at least in civil responsibility, we are simply talking about defamation. Whenever it comes to any damage to reputation, dignity, honor, it's still defamation. So if you really think that you were defamed and if you reviewed all your information, then the steps would be like that. First of all, of course, I would recommend to consult your lawyer to verify if you have a case, if you have enough evidence, if you have enough knowledge, and if you have enough understanding how to assess the consequences of filing such a lawsuit, because very often something which was not that big of an issue initially, if it became a lawsuit, it was spread and much more people were involved. And at the end, the damage to reputation, even in case of a favorable outcome of a lawsuit, because there are always rumors and something that is not judicially controlled, that damage might be even worse than it was in the beginning. So it's a good idea to assess the consequences. But let's say you did that and you're adamant you want to go there. So you consulted your lawyer and you have the understanding of the law and how to prepare your evidence and what you should collect, and you know all about that fault and causal link and the damage and how to prove each of them, and you're ready to do that. So you collect your evidence wherever your lawyer asks you, or if you prefer to do it on your own, whatever you think is needed. And usually in cases of defamation, that's the biggest part of preparation, because it's not enough to be offended. It's not enough to think that something was outrageous and unpleasant and of like extremely bad manners, bad education, something like that. It's necessary to collect your evidence, because at the end of the day, it's a civil responsibility litigation. So the question will be if the damage was caused, and how did you measure that, and how do you prove that, and how do you prove that the damage was actually caused by that particular behavior, and if that particular behavior was faulty in the sense that it was a fault of someone. So you collected your evidence, and with your lawyer, without your lawyer, you assessed the expenses to come, because again, no lawsuit is 100% guaranteed as to its result. So whether you win or lose at the end, the litigation itself, it's lengthy and costly most of the time. So you have to know, like at least in average, at least like some ballpark, some approximate figure. And again, then you compare that figure to the damage that you actually suffered or expect to suffer because of defamation. And of course, if the damage is significantly lower than the prospect of money to spend, then maybe it's not a good idea to file a lawsuit in defamation. But let's say again, you assess that and you're comfortable with the result of that assessment. Then, again, depending on what you want, you have to assess your options, because it's not necessary, like absolutely, to go to court, to go with a lawsuit. You might negotiate, you might go with mediation, you might prefer arbitration, you might organize for some mixture of all those, because if at the end you simply want that the other person stops telling, writing, doing whatever he or she was doing, and that maybe he or she compensates you the damage that you actually suffered. Maybe you wish an apology, so you know better what you want. And again, depending on how much you want, it might be better achieved, or at least you might have better chances to achieve it through some sort of negotiation, mediation, arbitration, something like before or instead of going to court. Take it seriously, but if you absolutely necessarily, for whatever reason, think that it's the best option to go to court, remembering, of course, that the judge in court will not decide who is a good person, who is a bad person. The judge will not interfere with your emotional quarrel. The judge will see if there was defamation in the sense of the articles of the law, and if the evidence you provided is enough to order some kind of compensation. Why I'm telling that, because very often when you're defamed or when you're feeling that you're defamed, you go to court basically asking to confirm that you are the good guy, a good person, and the other one is a bad one. But rarely you achieve that, because it's not the role of the courts to issue those moral kind of an assessment of people, appraisal or judgment in that sense, if you wish, at least in the civil court. Of course, sometimes something like that happens, but at least it's not a major role. So, okay, you decided that you wish to fight instead of negotiating. You go to court. So next step would be to prepare a letter of formal notice, mise en demeure, where you just repeat the facts as you know them, where you state your claim. So what do you want from the other person? You give some time frame that you're expecting the answer within this and this particular period of time. It should be reasonable. It should not be within 24 hours. If something to do that you're asking to do is requiring something like, I don't know, a week, 2, 3, a month or so. So the time you're allowed to answer should be reasonable. And then once you have sent it with a proof of delivery to the other person, you wait. And if you're both lucky, you will negotiate and again get to some kind of mutually acceptable agreement. And that will be the end of story. But if not, if the other party refuses, or if you're not satisfied with the answer, or if your letter of formal notice was closer to an ultimatum and it was not very much first step in negotiation, therefore it was refused, then your next step would be to prepare your application, to attach all the evidence as needed, and to send your application to the court, to register in court, to obtain the court number. Usually you do it via bailiff, but technically you can do it on your own, because in our legal system, most of the times, but for certain exceptions, you're not obliged to use lawyers or other officers of law or other people who can help you in that. It's just customary to do so, because without a lawyer, without just going through proper channels, if you wish, there might be certain disadvantage. But again, it depends on your level of knowledge and skills and so on and so on. So let's say that you hired a lawyer, then your lawyer would arrange for a bailiff. But if not, you could arrange for a bailiff, or you could simply go to the court office and discuss with the court clerk what is the best option for you to proceed with the proper steps. But the idea is that the other party should be informed of your actions and informed of your claims and informed of your evidence, and that you will need to provide to the court the proof that you actually informed the other party about all of that. So despite all of those novels where a lawyer comes last minute before a judge with something surprising to turn the litigation to the hearing completely, in reality, it's not something that we do, at least in the civil court of law. All the evidence should be provided in advance to the other party, to the court file, so that the other party in defense will have all the possibility to bring their own facts to the judge, and again, whatever the evidence they bring, you will eventually know. So it all should be more or less open and transparent when it comes to the evidence, at least, that you wish to present to the court. If you kept something to yourself at the very last minute, chances are that the judge will simply prohibit you to use something that you did not present to the other party in advance, and the chances are high, actually. So you notified the other party or the parties. You provided the proof of that notification to the court file, and from that moment, like more or less, you have about 45 days to establish a so-called case protocol. It's sort of a schedule of what actions each party at what moment will be taking in the next 6 months allowed by the law to prepare your court case. Of course, there is a possibility with the court's authorization usually that the time period will be longer, but at least initially you have 6 months to do the preparation. But in most cases, if yours is not one of the most cases, again, please consult your lawyer. And once you have established with the other party, so it's not at this point something that you can force the other party to do or not to do. It's more or less the informing each other of the steps that you're going to undertake. And then when those first steps done, again, usually you wish to negotiate, because very often you file a lawsuit in defamation to put additional pressure to show the other party that you were serious about all that. But at the end, you don't want a lawsuit, you don't want a just court hearing, you don't want a trial, you want a resolution. And most of the time, it's all negotiable, as long at least as it's about money or some measurable, financially measurable, monetarily measurable damage. But if the negotiation fails, then eventually you will have your hearing, you will have your trial, and you will have your judgment. So this is it, more or less. Of course, it's just a general picture, and all the particulars, again, normally should be discussed with your lawyer. Even if you go on with your own litigation preparation and everything, it's a good idea to have at least several consultations to understand the steps better, and to have a more or less independent evaluation of your evidence. And I wouldn't say your chances, because chances are never absolutely known. At the end of the day, it's all up to the judge if you did not negotiate before, but at least to assess where you're entering and what you will probably face on the road. That kind of an assessment is usually done with a lawyer, and you know your case better because of that. So this is a piece of general information about all that. The last thing probably to add, that the time period between the moment that you have prepared your case and the moment that you have your trial might differ from a year to 2, maybe sometimes even 3 years, depending on the backlog in courts and other nuances of your case. So remember that if you are getting into the idea of filing a lawsuit in defamation, you are getting into some lengthy and potentially costly adventure, if I may say so, at least like undertaking. So it's a good idea to think, and again, at least explore the possibility of negotiation. Thank you, and have a nice day.